Mr. Sampson?
Good morning, Your Honors. May it please the Court, Daniel Sampson on behalf of the appellants. I would like to reserve 5 minutes for rebuttal.
Okay.
This appeal presents a somewhat novel issue of Florida law. Are there any types of financial instruments that are defined as securities without resort to the economic reality test? The federal courts are clear. In the companion cases of Gould and Landreth, the United States Supreme Court ruled that any financial instrument labeled stock and bearing most of the usual characteristics of a stock is a security without resort. I'm sorry, Your Honor?
Or all? Real quick, the five-part test, all the five-part tests?
The court says most in Landreth, but it could be interpreted as all.
Go ahead.
Either way, I believe that this stock would meet all five. And the Florida Supreme Court is also crystalline. In Oppenheimer v. Young, 456 Southern 2nd, 1175 at 1177-78, that we are persuaded that it was the intent of the legislature in enacting the Florida Securities Act to rely on federal laws and enforcement efforts in the securities field and to cooperate with these efforts in formulating Florida law. The legislature intended that the Florida securities laws be hand in glove with the federal securities laws.
Let me ask you, if it weren't for Mortallite, in your view, I think I know the answer to this, but do you think, would there be any question as to whether the five-factor test applies here?
I don't think so. And there's no question that Mortallite is the best case for the appellee, but Clark v. Schimmel is the best case, ignoring federal law. The best case for the appellant is this court's decision in Clark v. Schimmel from 2000, in which this court held that a stock is a security without resort to any other test. Now, Landreth wasn't cited. What was cited was the American Law Dictionary. 2 years later, however, in Mortallite, this court then ruled as it did. However, there were several differences in Mortallite from this case. First, it was the formation of a business that was supposed to issue stocks. It wasn't a straight stock sale. Second, this court merely adopted the trial court's ruling on whether or not a stock is a security, and only pre-Landreth cases were cited by the trial court and by this court because it merely cited the trial court's ruling.
So, in your view, we would not have to go on Banc and recede from Mortallite? We would be able to distinguish it on that basis?
Yes, I believe this court could distinguish it on that basis, especially in light of the Clark v. Schimmel decision also from this court.
I don't think that Clark really informs the discussion very much, because Clark just pretty much said, as you said, well, a stock's a security under the plain language of the statute. But simply labeling something a stock, I think under Landreth it's pretty clear. That's just the starting point. If something says it's a stock, then you apply the five-factor test.
Absolutely.
But Landreth doesn't stand for the proposition that just because it's called a stock, we assume it's a stock.
Oh, no case stands for that proposition.
Right, and so saying a stock is a security presupposes that what you have is in fact what traditionally qualifies as a stock.
And I believe that we have that here.
Okay.
There are five factors, but first it should be noted that merely in the stock sale agreement, the word stocks or shares is used nearly 75 times, including 23 times on the first 2 pages. That may not be enough, but it's at least the starting point. Then, is there a right to receive dividends? Yes. The stock pledge agreement expressly states that the shares come with the right to receive dividends. That's the record at page 110. Is it negotiable? Also, the stock sale agreement expressly permits Githler to sell or assign Dr. Wish's shares to another purchaser at Githler's election.
Well, let me ask you this. If we agreed with you that the correct test to apply is the five-factor test, now you're asking us to make factual findings based on the record that the trial court did not make in the first instance. And maybe there is evidence to support them, but that's not our call. So I'm
not sure that it's a factual matter, Your Honor. These
Well,
are,
we would have to look at the evidence. I mean, they're saying it doesn't meet the five-factor test because X, Y, and Z, and you're saying it does, and you're pointing to parts of the record that support your position, and they're pointing to parts in the record that support theirs. That's not a comparison that we can make in the first instance, right? If we agree with you, we can't go that far. All we could do is remand for the court to apply the Landreth or the five-factor test.
potentially. However, in fact, they don't cite to the record at all in their single paragraph discussion of the five-factor test in the answer brief. There's not one citation to the record. What they say is, because it was later transformed into membership units, that it therefore is in stock. But the law is clear that you look at it at the time of the sale, not what was transformed. They then say, well, there's no right to receive dividends. But in fact, as a matter of contract law, there is a right to receive dividends. It's not a factual finding. It says right in the contract, there's a right to receive dividends. They cite to nothing, and I think that contract interpretation of all of these documents can be done as a matter of law. However, certainly, if the court were to reverse and ask the trial court to apply the five-factor test, I think we would all be back here in a year and a half, but we wouldn't object to that. If the court just has other questions regarding the stock characteristics, or should I move on to the double recovery issue?
If we agree with you that it has to go back for application of the five-factor test, that sort of disposes of the second issue too, right? We would never even reach that?
No. The second issue regards their counterclaim. So it's a separate, it's actually a sort of a separate ruling.
But if the whole issue, because you want the remedy of rescission, right?
Right.
So if the whole thing is rescinded and everyone's supposed to go back to where they started, that would necessarily vacate their counterclaim, wouldn't it? I mean, the court would have to revisit that too.
I would think so. I would think that the court would want to specifically direct the trial court of that though, however. But yes, I would agree that if the court reverses, that everything should go away, but I'm not sure that that will be the appellee's position.
Oh, of course.
Is that because if we could decide that more to light doesn't apply and that the five-factor test does apply, and then it could go back and the court could find that it wasn't stock,
Right.
and you'd be back in the same position because you believe that the appellee had a double recovery?
Yes, that is accurate. There would also be other issues on a remand. So let's say that the trial court were to find that it is stock based on the five-factor test, then their affirmative defense of the isolated sales exemption would be applicable, and the trial court would have to rule on that, which it has not done at all. And I would certainly agree the court can't rule on that, as it's factual in the first instance. But regarding the double recovery, the stock purchase agreement expressly requires a reasonable disposition of the shares. So does section 679.610 Florida statutes. The final judgment doesn't require there ever to be a disposition of the shares. Allen v. Coates is nearly on point. It is basically the same facts, repossess collateral, and there are numerous places in the contracts, again, matter of contract law, not facts, in which each share is valued at $3,502.38. That's at record 71. In that event, what they've done is they have repossessed all the shares of the company, chose not to sell them, not to dispose of them, and obtained the full amount. And the trial court didn't require a deficiency judgment. And even the case law cited, Stillman, by the appellees, specifically says they're right, that it's more recent and applies to the UCC. But the court says in footnote 5, in case anyone got a mistaken impression of our opinion, you cannot repossess collateral and simply do nothing with it. So even their own best case really goes for the appellant.
So it's sort of like the foreclosure case we just had. You've got the money judgment, you get the collateral, but there's an order in the final judgment setting the date or setting a time period for the sale of the property. And then you can, in those cases, the mortgagee can then go after the defendant for, as you said, the deficiency.
Yes, however, in this case, because of Allen v. Coates, we believe that the failure to dispose of the collateral, it's been repossessed for 3-4 years, means that it is worth the share price denominated in the agreements. And the agreements say every single share is worth $35.02 and change. And so our position would be that the amount of collateral is equal to the debt by operation of law because they repossessed the collateral. If the court disagrees with that, then yes, I would agree that the next procedure in line would be to at least require some sort of deficiency hearing. But this order, the final judgment, says that the shares never need to be sold unless Mr. Githler had not paid them. That means they'll never be sold. There needs to be, at a minimum, an order requiring some sort of disposition. But I believe that, based on Allen v. Coates, and even based on Spellman, that the failure to have disposed of it already means the amount of collateral is the amount of the debt. And if the court has no further questions, we respectfully request the court to reverse the trial court's ruling with regards to count 3 of the amended complaint, and with directions to either enter judgment that this is a stock or hold a hearing on the 5-factor test and their affirmative defenses, and or to reverse the final judgment permitting a double recovery. Thank you, Your Honors.
Thank you. You'll have your full rebuttal time, Mr.
Thank you.
Good morning. May it please the court? I am Kelly Garrity Price of the law firm of Cohen and Grigsby, and I represent the appellees, Philip and Marta Grande, in this appeal. I think that the court has crystallized the issue on the overarching appeal point raised by the appellants, and it was referenced by the justices just now in the questioning of counsel on that issue, which is, does Landreth apply? Does Mortallite apply? And you heard the concession by appellants' counsel that the best case that they have to support the arguments being made that Landreth applies and not the Howey test, which is what the trial court applied, is the case of the probate case, Clark versus Schimmel, that was cited, both in the brief and referred to in arguments this morning. Absolutely correct. Does not address Landreth, doesn't address the 5-factor test to be applied by Landreth. That is a case that involved probate issues and looked to a statutory definition or a common law definition of what a stock or a security is. To me, that case also does not frame either the factual or the legal findings that this court has to undertake. Quite clearly, there are only 2 issues on appeal presented by the appellants here. One is, did the trial court properly apply Howey, or should it have applied Landreth? The second applies to the counterclaim, and whether or not there has been, quote, a double recovery in favor of Marta Grande. We believe that that second issue on appeal is totally separate from the overall transaction, and yes, the court is correct. The remedy being sought by Mr. Githler in count 3 of his complaint was rescission of the entire transaction. But the promissory note stands alone in terms of the obligation of payment. And it was clear and undisputed at trial, even by testimony from Mr. Githler, that he defaulted on that note and what the balance of that note was due and owing. So I'll circle back to that at the end, but let me get back to the Howey decision. The appellants have tried to phrase this issue as one of first impression for this court, and have tried to imply that there is some public policy need to clarify the application of Howey to transactions like the one at issue in this case. I submit to the court that that's absolutely not true. There is a plethora of existing Florida case law that we have cited in our answer brief, and some of those were again cited by the appellants in their original brief and their reply brief, which talk about why and how Howey has been the test to be applied in the state of Florida when you're dealing with claims that are asserted under Chapter 517. There was not a single federal securities claim at issue in this case. The reason there wasn't is all of the documents relative to this transaction, from the stock purchase agreement to the operating agreement to the stock pledge agreements, all of those identified that Florida law would apply to any disputes that arose under these particular agreements. That's why Mr. Githler only sought relief under Florida statutes that may involve a security. There is not a single reference to any of the 5 characteristics of the Landreth test anywhere in the plaintiff's pleadings.
But the state statute is very similar to the federal statute. And if everything in the state is determined to be a security based on the Howey test, which originally came out of the context of investment contracts, then why did the legislature delineate all these different things as securities if the whole inquiry simply boils down to, is it an investment contract?
The investment contract subsection in Chapter 517 is one of the many ways you can define a security. And most of the case law interpreting, quote, investment contracts interpret that as being the overarching sort of catch-all for these written agreements or even oral agreements that exist relative to the purchase of an ownership interest in a company. It is one of the ways. There are other ways enumerated in our statute, none of which apply to this particular case. And the reason for that is clear. This particular stock purchase agreement was an agreement whereby Mr. Githler and others were purchasing a majority ownership interest in Spotlink, which at the time was a Florida corporation. The vehicle by which that ownership interest was transferred was common stock. But the stock purchase agreement, the operating agreement, all of the stock pledge agreements clearly reference an intention and understanding that as soon as this transaction closed, and as soon as Mr. Githler assumed his roles as chairman of the board and vice president of the company, that the company would convert to a Florida limited liability company. There are express provisions in the stock purchase agreement regarding that, as well as in the operating agreement. So it was never intended or structured that this would be a stock transaction.
But two things about that. One, aren't we bound to look at the transaction at the time it occurs as opposed to what's contemplated down the road?
I don't think so, and let me say why. The cases cited by the appellants in their reply brief don't frame that issue in the context of a sale of unregistered securities. All 3 of the cases cited by appellants in their reply brief address a securities fraud claim under federal law and what the loss compensation or loss causation elements of that particular cause of action would be. And in fact, one of the opinions cited by the appellants identifies 3 different tests by which you could apply that. So it's not the same issue, but even if the court were to say, yes, we have to look at this transaction as a whole, when the parties executed the agreement in October of 2013, when you look at the agreement as a whole, it's clear that this was not going to be a stock transaction. The stock was to be converted to shares of limited liability membership interests immediately upon the closing and immediately upon Mr. Githler and the purchasers becoming the majority owners. The only governing document that exists anywhere in the record of the trial below or for purposes of this appeal is the operating agreement. And candidly, the appellants didn't even address the operating agreement in their initial brief.
But under Gould, does that matter? Because doesn't Gould reject the whole sale of business analysis?
It does, Your Honor. And Gould involved a 50% sale of an ownership interest in a business. Landreth involved 100% sale. Well, we don't have 100% sale here. We have an 84% sale of the ownership interest in Spotlink. Gould, however, does not stand for the proposition that just because you use the term stock means that it's a stock transaction.
No, but it does say that's where you start, doesn't it? If it walks like a duck, you see if it talks like a duck too, and if it doesn't, then you look to see what else it might be, but doesn't Gould, read together with Landreth especially, stand for the proposition that if something's called a stock, that's your starting point, and if it doesn't fit that 5-factor test, then you go on into the economic reality test and Howey and see what else it might qualify as?
I think that's correct, Judge, if you can meet the specific 5-factor test. And don't forget, Landreth and Gould only applied to federal securities claims. And in both of those cases, it was presumed by the parties involved that federal securities laws would apply, and that was identified in their agreements. That's different from the case here. We don't have a single instance of Landreth or Gould being applied to a state court case in Florida. And the reason for that is clear when you read all of the decisions that we have cited in our answer brief about why and how it gets applied. But the reason this case isn't governed by either Landreth or Gould is there is no way this particular transaction meets the 5-factor test. The operating...
I'll ask you the same question, though, that I asked your colleague. Can we make that call in the first instance?
I don't know that you can, Judge, and that's one of the reasons that we cited in our answer brief, that this whole issue of does Landreth apply was never pled. It was never anywhere in any of the pleadings, any of the replies to affirmative defenses, any of the pretrial filings. In fact, even on the summary judgment motions, which were brought in the trial below before trial, we had 2 of them. The second one dealt only with count 3 of the plaintiff's complaint, which was the alleged claim for sale of unregistered securities. We put the Howey test squarely at point in that second motion for summary judgment. It was contested by Mr. Githler. That particular opposition did not say, hey, court, you're applying the wrong standard. It should be Landreth. It shouldn't be Howey. Landreth never came into play until post-trial motion practice.
But that appellant is saying the application of the 5-factor test here is completely an issue of law because it would all be based on a reading of all of the agreements, whether the 5 factors applied to establish that this was stock.
And I believe that flies in the face of what the decisions say, Judge. But even if that were correct, looking at these documents, looking at the stock purchase agreement, looking at the stock pledge agreements, and looking at the operating agreement, it's clear the factors are not met. These shares of stock or ultimately membership interests could not be negotiated or transferred.
Do you mind if I pause and go back to something you said before we go into the
Yes, sir.
factors? It sounds like what you're doing. You said that, and I don't want to speak for you, but you said that Landreth doesn't apply here, and I understand Landreth to mean if it's labeled stock and most or all the 5 factors are applicable, then it is stock. That test doesn't apply here because you said it doesn't meet that test. It sounds a little circular. You said, so apparently what you're saying is that the economic reality test applies because it doesn't meet the Landreth test.
No.
In other words, the Landreth test doesn't apply because the Landreth test has not been met.
Landreth doesn't apply because it's not the law in Florida, Judge. It has never been applied in a state court case, and it has no application to a Chapter 517 claim, period. That's the overall issue, number one. The appellants are trying to take a square peg and smash it into a round hole by saying Landreth applies. Landreth doesn't. The case law construing our blue sky laws make that clear. There were opportunities before the courts, the appellate courts, in all of the years since Landreth or Gould were decided to make it clear that that does apply to a Chapter 517 claim, and they haven't.
Have they ever squarely rejected that it applies?
It has not been applied anywhere in state court.
We haven't had such great attorneys before.
Well, perhaps, Judge, and maybe that's the case, but We identified 3 cases in our answer brief in which Howie was applied to a transaction that involved the sale of stock. Those cases, both pre- and post-date Landreth. For purposes of this particular inquiry, there has been no case law that even guides the court to an application of Landreth, which clearly is limited to federal securities claims in a situation where you had all common characteristics of stock and all of the parties justifiably relied on the fact that this was a security transaction subject to federal security laws. We do not have that here. The reason we don't have that here is all of the agreements identify Florida law is going to apply, not federal. All of the documents associated with this transaction, which was complicated and very much subject to lawyer review and drafting, every single one of the key documents identified that this was a sale of unregistered securities. The stock purchase agreement, the stock pledge agreements, all identify that these shares of stock are not part of any public offering.
But isn't what you just said, I mean, you're sort of conceding that they were securities, though?
No, Judge, I'm not.
If everyone's operating under the assumption that they're securities, and the parties don't decide whether they should be registered or unregistered, that's a question of law. But if you've already presupposed that they're unregistered securities, you're conceding they're securities to begin with. That's not the case, Judge. We are not conceding that they were securities to begin with. In this defense of the fact that this particular transaction, in the way it was structured to fit Mr. Githler's needs, was never intended to be a securities transaction. However, good lawyers have to draft documents to cover all potential exposure. So in the event that any court were to look at this and decide that this was a securities transaction, despite the overwhelming evidence that it was not, the documents were structured such that 2 exemptions would apply under Chapter 417, the isolated sales exemption and the private offering exemption. So it's not a concession, Judge. It's good lawyers doing their job. None of the parties intended this would be a securities transaction because of the element of control over the operation once the purchasers had the 84% controlling interest and the conversion of the company to a Florida limited liability company. You couldn't negotiate or hypothecate any of these shares of stock that were purchased pursuant to the stock pledge agreements, both the ones between Mr. Githler and Ms. Grande, as well as the stock pledge agreements that existed between Mr. Githler and Donald Conswell. Additionally, the operating agreement contains a number of provisions that prohibit the transfer or sale of any of the membership interests or stock shares subject to certain provisions in that Article 10, and some of those are a right of first refusal for the existing members. Additionally, the pledge agreements have the same language that prevents any transfer, hypothecation, or pledge of additional security separate and apart from the private financing that was a part of how Mr. Githler financed his acquisition of this 84% ownership control. I heard counsel reference that there was a provision in the stock purchase agreement that allowed Mr. Githler to hypothecate the shares that Dr. Wish was going to purchase. He takes that provision out of context, and you will see it in Section 1.2 under Article 1 of the stock purchase agreement. And that is the article that describes the 60 shares that were being purchased by Dr. Wish. And that article clearly says that that purchase is predicated on Dr. Wish making a capital loan of $100,000 to the company. And that if he didn't purchase his shares and didn't make the capital loan, then that section says Githler has the obligation and the duty to purchase those 60 shares from Marta Grande within 90 days thereafter at a purchase price of $228,000. It doesn't say that anybody can purchase those. There's one further sentence that said the right to purchase by Githler shall be assignable to another purchaser at Githler's election. But those are all conditioned on caveats to Dr. Wish not performing his obligations. Let me transition briefly, if I can, to the issue of the, quote, double recovery in the counterclaim.
we start from this premise, that we had a promissory note that secured the majority of the purchase price of this particular transaction, with Marta Grande being the one providing seller financing. That promissory note was for roughly $1.8 million at the time it was made, required certain payments, and it had collateral in two forms. One form was the 508 shares that Mr. Githler had not paid for at the closing, where the down payment of just over $1 million was made. Those 508 shares were pledged as collateral pursuant to a stock pledge agreement between Mr. Githler and Ms. Grande, which clearly gave her first priority position and clearly prevented him, with the exception of allowing some of those shares to be sold to Mr. Cogswell, and with the exception of allowing a security interest to Trey Dessenberg, the private person who provided the down purchase money for the purchase of the shares at closing. With those two exceptions, none of the shares of stock that were pledged as collateral could be transferred, hypothecated, sold, or done anything with, because Marta Grande held a first position. Those 508 shares were one form of the collateral. The other form of the collateral was Section 1.6 of the stock purchase agreement, which required Mr. Githler, if he sold his residence in Sarasota, which was listed for sale at the time of this particular transaction, if that sale closed before the 24-month term under the secured promissory note had expired, then Mr. Githler had the affirmative obligation under that section of the stock purchase agreement to take his net proceeds from the sale of that residence, and that is defined in that Section 1.6, and apply it to the promissory note to reduce it down to a sum of $500,000. So there were two forms of collateral. Those forms of collateral were at issue in the counterclaim, as well in the claims that Marta Grande asserted in the interpleader action, which resulted when Mr. Githler did sell that residence, but failed to comply with that Section 1.6 of the stock purchase agreement. Those were the claims at trial relative to the collateral. Nowhere in any pleading filed by Mr. Githler, whether in the securities case and the breach of contract case or in the interpleader case, did Mr. Githler ever raise the issue of 679 as to any of the collateral held by Marta Grande. It was never asserted. In response to the counterclaim, in the case in chief on the stock purchase agreement, Mr. Githler raised three defenses. Unclean hands, which is an equitable defense, which for reasons we've stated in our brief don't apply. Two was that there should be an offset to any recovery to Marta Grande under the promissory note for the 303 shares of stock that SpotLink was obligated to repurchase from Mr. Githler should he default on the promissory note. That provision, that obligation exists again in the stock purchase agreements when you read sections 1.5 and 1.6 together. That obligation required the company to repurchase the 303 shares that Mr. Githler received at closing when he paid his $1 million plus down payment. So he had those shares, but they were subject to that covenant, and they were also subject to the financing he had done with Trey Dessenberg, where Mr. Yes?
I've given you a little extra time, but you need to wrap it up.
Okay. So those issues were never raised. They were never pled. The Coates case predated the comprehensive overhaul of the Uniform Commercial Code that occurred years after Coates. The cases that we cited, the Spellman case in particular, is absolutely the case law to apply, which says that the rights to a creditor are cumulative and she can exercise any and all of them. There has been no evidence of any double recovery, and the Uniform Commercial Code now requires that the debtor put the issue of whether or not the secured party properly handled the collateral at issue. We provided the court with the statutory citations to the current code under Chapter 679. All of the appellant's argument is based on pre-revision to the UCC code. It's old case law, and they simply miss the mark.
Thank you.
Of course, the federal securities laws are interpreted the same as the Florida securities laws. The Florida Supreme Court says so, hand in glove. Now, it should be noted that when the court goes and looks at that case, it was vacated by the U.S. Supreme Court on other grounds, whether or not the Federal Arbitration Act preempts state securities laws. The part about hand in glove, it was not vacated. In fact, 6 years later, it's cited and quoted by the 11th Circuit as what Florida law is. As regards the litany of cases that Ms. Price says show Florida follows Howey in all instances, that's just simply inaccurate. Case 1, Venezia v. Sunrise View. It's about a foreign currency investment program and whether that was an investment contract. Mel v. Office of the Florida Regulator. It's about a telephone sale and leaseback program and whether that's an investment contract. Mortallite, we've discussed. Greater Ministries v. State. It was not a security, but might have been an evidence of indebtedness or an investment contract. Verhagen v. Montigny, an oral joint venture contract calling for the issuance of stock, but the parties conceded Howey's applicability. And finally, State v. Feldman, it was a note secured by a mortgage. So in fact, no Florida appellate court has had occasion to address this. The only court that it's even cites it is the 4th District in Edelstein v. Flanagan, and what they said is, we don't have to decide this because we're reversing on a different ground. I thought that I want to answer Judge Rothstein-Yoakum's question to Ms. Price, which was about the enumeration of different types of financial instruments and whether or not the statute has to be construed to not render all of that superfluous. Interestingly enough, in the Landreth Court addressed that and says that it would make the enumeration of them to be superfluous, and it cites a Second Circuit opinion, Golden v. Garofalo, in which the court says, in talking about the legislative history behind the 33 and 34 Acts, there was little reason for the drafters to use words such as stock, treasury stock, or voting trust certificate, unless their intention was to include all such instruments as commonly defined. If an economic reality test were intended, reference to such specific types of instruments and common variations of them would have been inappropriate. The same thing applies to the Florida legislature and its enumeration of many forms of stock. Again, we look to the time of the transaction. That's in Gould, it's in Landreth, not at what might have happened later, as well as if the court looks at section 10.8 of the stock, I believe it's the stock pledge agreement, that section says it might be converted at Githler's decision. So when he purchased this stock, he was under the impression that he was buying stock, just as the Landreth case says. Even savvy investors see stock and assume that that's what they're being purchased. Now, as for unregistered securities, again, I think that's a very good point, that it is a concession that they are indeed securities. There's also nothing wrong with selling out unregistered securities as long as you qualify for an exemption, like the isolated sales exemption. But then the trial court would have to decide whether or not Dr. Wish received a finder's fee and whether or not there was full information given, with the burden being on the appellee as opposed to the appellant when they were trying to prove the fraud claim. The double recovery. The promissory note does not stand alone. If the rescission of the shares is granted, then the loan never happened also, ipso facto. If Githler never purchased the shares and the whole sale is rescinded, then the promissory note has to be rescinded also. As for the pleading issue, we pled two things. One did relate to the 303 shares, which were valued at $35.02 and change. But they were on notice that every single share was $35.02. That's page 71, which says every share, not the 303 shares only. Moreover, it's in the counterclaim's prayer for relief that the collateral should be sold and offset against a judgment. Why would we need to assert an affirmative defense that merely asserts the same thing as the counterclaim's prayer for relief? There's never been an answer to that question by the appellees because there is none.
All right, Mr. Sampson, you need to finish up.
I would request that the court reverse as to count 3 on the Landreth issue and/or reverse as on the double recovery issue. Thank you. And I apologize for being a little sick and having a rough voice.
It's fine, very, very well argued on both